Right. So we'll start now. Just to say good morning to everyone and welcome to the meeting of the Licensing Subcommittee on Wednesday, the 4th of May at 10 a.m. My name is Mark Thomas. I'm the Democratic Services Officer and I'll be supporting the meeting today. Before we choose the chair, etc., just got some housekeeping items to go through first. Can I just ask all participants to confirm they've received and read the papers, including the procedure, etc.? Okay. I think the broad consensus. Yeah, lovely. Thank you, everyone. Bear with me a second. Also, can I just advise, during the course of the meeting, could all participants please mute themselves when not speaking, in order to avoid any background noise or feedback when other participants are speaking. If a participant does wish to speak, can they please put their hand up if they can be seen, or use the hands up option, which is also on the application of Teams. If any participant has difficulty hearing or being heard, then they should let either the chair or supporting officer know. If they have a webcam, then in the first instance, they should try turning this off, as this will help broadband or Wi-Fi bandwidth, so at least they can hear and be heard. If a participant still has difficulty with their connection, can they please let myself know or the chair, and if required, participants can dial into the meeting as well using a telephone. There is a telephone number provided on the link or invite you've been sent. If the BEV should occur, then the chair, to say for any technical reason any party to the proceedings is unable to continue the hearing will be adjourned for a short time in order to allow contact to be made. It's obviously important to remember that all parties must hear all the proceedings unless they themselves decide to leave. As a chair will need to be appointed, I will now seek a nomination from the members sitting on the committee today, and a vote will be taken for the chair for the duration for the subcommittee. So, members, can I ask for a nomination? Councillor Norman?
I nominate Councillor Thomas, please.
And I'll second.
Okay, that seems unanimous. Councillor Thomas, congratulations. You're appointed for the chair for the purposes of the meeting. Thank you. I'll hand over to you.
Thank you, Mark. Thanks everybody for attending. Can I first of all apologise for the fact that we're still meeting virtually, but the council have decided to continue to follow the Welsh Government guidelines. Hopefully, once we get into the new council term following the elections this week, we can get back to some form of normality with face-to-face meetings. As you've heard, my name's Councillor John Thomas, and I've been appointed chairman of the meeting this morning. The other members of the subcommittee are Councillor Margaret Wilkinson and Councillor Jane Norman, and we are here this morning to determine an application under the Licensing Act 2003 for the grant of a premises licence at the Old Bank, 1 Elm Grove Road, Dinas Powys, CF64 4AA. Before we start going through the report, could I just ask everybody if they would like to introduce themselves so that we know who everybody is? So in no particular order, because I think everybody's screen probably got people in different places. So
my name's Richard Romero, and I'm representing Shared Regulatory Services, the noise pollution team.
Okay, thank you, Richard.
I'm Councillor Margaret Wilkinson. I represent the Gimsdown ward, and I'm a councillor on the Vale of Glamorgan.
I'm Councillor Jane Norman. I represent Llantrip Major on the ward on the Vale of Glamorgan Council.
My name is Matthew Phipps. I'm a solicitor presenting the application on behalf of the applicant this morning.
My name is David Abbott. I'm the designated premises supervisor.
I'm Richard Price. I'm the legal advisor to the subcommittee.
Good morning. I'm Anthony Obeid and I'm co-owner of the Old Bank Dinas Powys.
My name is John McQuaid. I'm a Dinas Powys resident and co-owner of the Old Bank.
Yvonne Witchell, the team manager for licensing for the Vale of Glamorgan.
Right. Is it my turn?
Yes, Mr. Evans.
Right. My name's John Evans. I'm a local resident.
Thank you very much. I think that's probably covered everybody. So moving on, can I ask the licensing officer, Yvonne, if you will take us through the report, please?
Thank you, Chair. Good morning, everyone. As the Chair has explained, this purpose of this report and meeting is to consider an application under the Licensing Act 2003 for a premises licence for the premises known as the Old Bank, Elm Grove Road, Dinas Powys, and it's submitted on behalf of Roberts McQuaid Limited. The reason for the hearing this morning is that the application has been advertised and representations have been received. At this point, none of the representations had been withdrawn, so a full hearing of the application is required. Within your report, members, we briefly outline what's happened to date. The application has been received and it seeks the authorisation for the licensable activity of the sale by retail of alcohol on and off the premises. The application includes an operating schedule which sets out the steps the applicant proposes to take to promote the licensing objectives, and this operating schedule forms part of Appendix A to your report. The application was advertised and served on the responsible authorities. Representations were received during the consultation period from shared regulatory services and from other persons, and these are attached to the report in Appendix B of your bundle. There were 16 emails received supporting the approval of the premises licence application. The authority is only empowered under the legislation to consider relevant representations received as defined in the Licensing Act, and the representations were considered and presented having regard to the Section 182 guidance issued under the Licensing Act by the Home Office. None of the representations were deemed frivolous or vexatious. The rest of your report relates to the powers available to the subcommittee on the determination of this application. We have also received additional documentation during the lead up to the hearing this morning. No doubt the applicant and the other person, Mr. Evans, will go through that with you, but that involves promotional material, a transcript of an email, a set of menus and amplification of representations. Chair, that is the report that we have for you so far. I don't know if there are any questions in relation to the application process.
Thank you, Yvonne. Any questions for clarification at this stage? If not, then can I ask Mr. Phipps if you will put the case for the applicant, please?
So thank you very much. Just turn my mute button off. Thank you. So delighted to be involved in this application. The attendees have introduced themselves. Excuse me. But I do say and will say that the experience and expertise involved here is significant. David particularly, who has significant experience of operating premises in South Wales and also particularly in the centre of Cardiff, including Mill Lane, has operated within South Wales Police control and supervision for a number of years. They employ in Cardiff a traffic management system, a traffic light system as it's known, where premises are categorised red, amber and green, red meriting special measures and often formal action plans, if not enforcement activity. All of his premises have always been green. And he is also SIA registered and proposed to be the DPS here. The application site, as you will appreciate, is in Dinas Powys. Essentially, this premises was formerly a bank, became vacant in about 2017. COVID, obviously, and you've touched on the very fact that we're having another remote hearing. COVID, if not continues, at least has created a 2-year interruption to all our lives, and obviously business was not helped by that. But essentially, this is an investment into the former vacant bank, creating a proposed hospitality premises, which seeks to have the benefit of an alcohol license. It's right to say that recently another hospitality premises in the village closed, and we are pleased to articulate really a blossoming confidence in terms of investment and development of this premises moving forward. We have produced some evidence, which Yvonne has mentioned. I've seen the original agenda and can take you to the various page numbers on that. I haven't seen where the materials that we and Mr. Evans have provided has been, so I can't give you page numbers, I'm afraid. I don't know if there is a secondary agenda or something like that, but if I just mention the materials, sir, and then if they're unfamiliar, we can dig them out.
Yeah, sorry, Mr. Phipps, just let you know that those materials have been shared with members, representatives, so they are aware of them. It's just
that's great.
Various factors they've not been put onto the website or as part of the agenda as yet.
No problem. Well, look, thanks for the explanation. That's fine. I'm not planning on taking a long time on these materials. I just wanted committee to make sure that they'd had sight of them. So there's some photographs of the interior of the premises. There's some material that includes menus, drinks lists, just to give you, forgive the obvious pun, a flavour of the premises. The plan of the premises is on page 36 of your agenda, and that will be an important document for you to have consideration of, and you'll see that the premises is laid out exclusively to tables and chairs with a central bar service point. And there's some photos of tables and chairs set out outside where we would like permission to accommodate customers outside. Hopefully those are helpful. And there's a couple then of other little bits of material about the co-working government scheme in which we're involved that in due course I'll touch on, but only briefly. So the venue is going to have an extensive food and drink offer. Not every customer will be obliged to eat, but it's anticipated that most, if not all, will take some form of refreshment aside from alcohol. That's been very much the experience of the business that we have enjoyed so far. The premises has been trading without a premises license since about the 7th of April. Obviously, license isn't required for trading coffee and food during the day and evening. We have used some temporary event notices. I'll come back to that in due course. Service standards are critical to this business. The applicants are extremely keen to ensure that every single customer is treated well and will leave the premises eulogising about it to others. Staff will engage with customers throughout their stay at the venue, and whilst bar service is available, there'll be table service throughout and at all times. On a human level, the premises will employ up to about 20 members of staff, all of whom will be drawn from the local area. And from a working perspective, the co-work scheme that I mentioned, which is in some of the supporting materials, we've engaged with that government-sponsored scheme effectively to provide space and to accommodate those who are working from home, as is obviously much more the fashion these days than it was 3 or 4 years ago. The application is set out on page 26 of your agenda, and the operating schedule, the conditions under which the premises will operate, set out on page 31. In our view, the proposed operating schedule is perfectly legitimate and proportionate to the activities that are being proposed, and you'll know that reasonableness and proportionality are key words within the context of licensing applications. And that's something that it appears that the responsible authorities agree with. No representations, no adverse comment from police, fire, planning, health and safety, child protection, etc., etc. We also, whilst we have a representation from environmental health, they have not made any proposed amends, improvements, additional conditions or anything of that nature within the substance of their representation, nor since that was submitted, nor since our application was submitted. So hard to see that anyone really criticises that operating schedule at all, certainly from a responsible authority perspective. The conditions to which I'd particularly draw your attention are table service, customers seated, food availability, no drinks promotions, CCTV, incident book, personal license holder on duty, dispersal policy, closure of windows and doors at 10 p.m, rear courtyard only to be used as a means of escape and not to accommodate customers, and a challenge 25 policy. I'd suggest it's comprehensive and effectively attends to all the matters that you would hope to see in a professional operating schedule, as your licensing policy indicates is expected. The hours of operation are not excessive. 10 a.m. till 10:45 p.m. for sale of alcohol, 10:15 on a Sunday, with a 15-minute proposed drinking up time, as certainly we used to call it, 11 p.m. closure, all customers gone, 10:30 on a Sunday. That clearly doesn't allow for the conclusion that the premises is or could operate as a pub. Indeed, the pubs that are 8 yards over the road, that's 2 pubs from these premises, have licenses that extend beyond an 11 p.m. finish as here. In restaurant terms, I would suggest that 12 midnight is pretty standard, and so it's fair to categorise this as a modest and appropriate application for the location in which the premises finds itself. Important also to flag there are no other licensable activities being requested other than the sale of alcohol. There's no regulated live nor recorded entertainment proposed here, albeit of course, as you'll know, recorded music is permitted as it is in all licensed premises, and there's a deregulation by government introduced in the Live Music Act of 2012, which allows music to be played, but it doesn't categorise as a licensable activity. So we undertook pre-application consultation, again in line with comments from your licensing policy, and had a dialogue with the police prior to the submission of the application. Amends were made to the application reflecting some of the feedback that we received, and that may very well account for the lack of representation from the other responsible authorities as well. You will find within your papers an email from the police to my client, which he can talk to you about if required. It seemed to be suggested in the representations that the premises has been the subject of a police visit or police concern, and that seems to be bluntly wrong. And hopefully that email will provide you with conclusive evidence of that. The national guidance, for the benefit perhaps of your legal officer as much as anyone else, at paragraph 911 is important here. And the national guidance says that the police have a key role in managing the nighttime economy and should have good working relationships with those operating in their local area. The police should usually therefore be the licensing authority's main source of advice on matters relating to the promotion of the crime and disorder licensing objective. The section goes on, however, any responsible authority under the 2003 Act may make representations with regard to any of the licensing objectives if they have evidence to support such representations. So we'll turn to the or move toward turning to the objections. But important to flag that we have utilised temporary event notices during the period since the beginning of April to allow us to trade with alcohol. And the reason we've done that is not to undermine the licensing process and without in any way being rude to my client, but we didn't make the best fist of the first application that we submitted. The licensing authority reviewed the application, weren't satisfied with the formalities and effectively made us reapply, which is how we come in front of you today. So we have used temporary event notices. I think that the ones that have been granted were granted 1st to the 2nd of April, 14th to the 17th of April, 19th to 24th of April, 30th of April to the 2nd of May, and there actually is one in place from the 5th of May to the 8th of May. We've not had any objection to those temporary event notices, either from the police nor from environmental health. From the trade that we've so far experienced, profile has been 25 to 50 plus, gender split fairly even 50-50. And perhaps pricing is a feature of that element. You have the menus and the drinks lists in front of you, and the fact that we've got no facilities for vertical drinking. Indeed, we unashamedly say that we're a much needed alternative to a pub environment, which is well catered for within the village. Certainly not here to criticise public houses, but it isn't a public house. The decor, the design, the layout, the food makes it very clear that it's not, and therefore we say unashamedly it's not likely to generate the sort of concerns that public houses from time to time may generate. In terms of the two public houses that are effectively over the road, I ought to also add, because the outside area is a feature of the concerns articulated by residents, that there is seating capacity for 48 outside the front of those two premises. Our proposal, I think, is for 8. So some significant work's gone into conversion of the building. And one of the concerns about the application that's put forward by residents is effectively to suggest that the premises hasn't been suitably insulated. We simply don't accept that. We've provided you with a letter setting out all of the, or a fair indicator of all of the works that have been undertaken in order to insulate the premises properly, and that's been provided by a quantity surveyor. Fair to say there was little or no insulation when the premises traded as a bank, and we have done a simulated acoustic test with appropriate experts in order to ensure that those works are delivering. It's had to be a simulated test because we've not been allowed access to the upper floors by the occupants, despite requesting access in order to undertake those tests. Matter for them, of course, but we've done certainly the best that we can. In terms of music being played within the venue, we do have music, as pretty much all licensed premises have music, and we have 6 small mounted wall speakers for background ambience. It's played always at a level that allows conversation between patrons, which is critical to the operation. We have a precision gold NO5cc, which I can't pretend I can talk to any more than that, noise level device to do some monitoring and testing to check that our levels are in order. We have, of course, residential objections to the application. Just to be clear, we don't accept we are a problem premises, nor that we are likely to ever be one. Our hours are reasonable. We are small in size. We're all seated. Food underpins the offer. The rear service yard that's complained about is just a rear service yard and is an escape route and no more than that. We don't accept that up to 8 customers being outside on the pavement is a source of legitimate concern or complaint. We don't accept that those smoking outside the premises will likely be a public nuisance. 12% broadly of the population smoke. Accommodation in the premises is maximum about 50. That's about 6 people. They don't all smoke all the time. And of course, the council themselves have placed an allocated smoking bin outside the premises on the corner. We do note that some of the representations make complaint about the movement of chairs within the premises. And whilst that may be a perfectly legitimate point to be brought to our attention by those who live above, I'm candidly struggling to accept that someone who appears to live 5 miles away from the application site in Barry can give legitimate evidence about that, as one of the representations seeks to do. But we're not here to cause nuisance to anyone. We don't want to have a combative relationship with our neighbours. Dampeners have been attached to the stools. We are happy to work with anyone to make sure that the premises trades with a minimum of fuss and disturbance. There are a number of points that are made in the additional documentation that's been provided, I think, by Mr. Evans, who's in attendance, but certainly by one of the objectors, that was sent across yesterday. I think licensing solicitors always do well to remind themselves not to think that they're in Crown Court on these licensing hearings. And so what I'm minded to do, Chair, if you were happy for me to, is just make some comments about that email rather than have some cross-examination of Mr. Evans, which I always think is a bit unsatisfactory in a licensing context. Happy to take a lead from you, but if you're happy for me to provide some comment on that email, I will now, if that's okay.
Yeah, I think that's fine if you comment on it, and then if Mr. Evans has any further questions, he can come back in.
Yeah, exactly. I'm not proposing to make comment about all of it, but
Mr. Evans is indicated. Can I just ask him?
Sorry, of course.
Just that I've got no problem if you want to ask me any questions. That's I know this isn't a sort of ideal mechanism for doing that.
Yeah, I think what Mr. Phipps said, he'll address the questions that you put in writing, and then if you've got any further questions, you can ask them then.
That's fine.
Okay, or if he doesn't cover it adequately for you. Okay.
Yeah, well, thank you, Councillor. Thank you for the steer, Mr. Evans. So look, Mr. Evans's email has got a number of numbered points. If I stick to the numbering, I'm not planning on touching on all of them. So, for example, Mr. Evans is concerned about why we've got a remote hearing. Chair, you've rather dealt with that. I mean, I think we'd all probably rather be back in person, but we are where we are. There's not much to say about that. So the first point to make is on bullet point 5. The reason we've not applied for late night refreshment is, of course, that only commences at 11 p.m. at night until 5 a.m. and we don't trade, nor does our application seek to allow us to trade in that window of time. We say that we're a unique proposition, number 7 on the bullets, because we say there's no one else in the village that can compare with us or our offer. We're different. And in terms of bullet 8, a more mature and mixed social demographic, that's been our experience of what we've traded so far. We're not a public house. We're not a kebab shop. We've been attracting people who are different to the likely attendees at those premises. In terms of our providing off sales, we would like the opportunity to have off sales. And that set out, the concern by Mr. Evans is set out at page 10. And he says, where would uncontrolled consumption take place on the way home in residential streets? Well, in terms of this being a point about the degree of control and supervision that premises permitting consumption on the premises offer that off sales don't, we'll accept this perhaps slightly backhanded compliment, and we're grateful for the commentary. But what we are suggesting is not that we're a shop or an off license, which trade perfectly lawfully up and down the country, as you will all be aware. We are saying that if someone has an unfinished bottle of wine at the end of an evening, we'd like to allow them to take it home with them. That's it. That's the extent of the off sales that we are interested in. And that's why we say to our customers, because it would be our customers who were within our premises. And we don't accept that in any way that could fairly be said to undermine the licensing objectives. There's talk then about the noise protection standards within planning, and your legal advisor will make comment about the points about duplication within your licensing policy and the national guidance, and the fact, frankly, that planning haven't made a representation to this application. But to be clear, we have done the works that have been required. We haven't been allowed access, so we've had to do a simulated test. But that apart, we are in good order in the context of noise protection. It's right that bullet point 12, this is a small venue, and it's right that if activities are not managed and controlled, there'll be significant outside public disturbance. I don't know about the significance of public outside disturbance, but it's a fair point to make. If premises are badly managed, then that will cause problems. We all know that to be true. That's not the basis on which one refuses an application at all. That's the basis on which enforcement and monitoring and supervision and control of premises occurs. We don't accept any of that applies to us at all. Then at 13, there's concern about our making the point that 50% of the premises is laid out to tables and chairs. What that really means is the whole of the premises is laid out to tables and chairs. But you can't put 100%, obviously, because then there wouldn't be any room to walk between the tables and chairs in order to get yourself a seat or a table. Customers can go to the bar. We're having waiter-waitress service throughout. The additional 50%, if you will accommodate the gaps between the furniture. Then at 15, question about a personal license holder and how that relates to a designated premises supervisor. I'm not sure that I need answer that because I suspect the committee are aware, but the designated premises supervisor is a personal license holder. And having a personal license holder on duty doesn't mean it has to be the designated premises supervisor, but it does mean they need to be a personal license holder. How will patrons at 16 be prevented from taking their drinks outside when smoking? Well, I'm not sure that they will. There's nothing wrong with customers taking a drink outside, just as there isn't anything wrong with it in the pub over the road or both pubs over the road. What there's something wrong with is people being poorly behaved, causing nuisance, causing disturbance, not being supervised, not being monitored. And we are entirely cognizant of that, and we'll be undertaking that. And then there's some comment about the shared regulatory services that says it's worrying and damning of both current and future operations. I'll turn to regulatory services in a moment, but all their representation does, quite clearly, you can read it for yourselves, is say we have received complaints which we have not investigated and we bring those to your attention. That's it. It's also right, touched on in your agenda, that there were 16 supporting representations to this application. Those have been excluded from the papers. As it said, they don't address the licensing objectives. I've not seen them, so I can't quibble with that. But I do say that it's a feature of the case that residents have objected. Obviously, we wouldn't be here otherwise, but it's a feature of this case that more residents sought to support the proposition. And they may not have done the legal framework correctly, which has meant that their representations are not within the papers. But it doesn't mean the premises is without support, and any suggestion that the community are opposed to this application would therefore be quite wrong. Turning to the officer objections, so it's clear, and I can get you the page number, but the representation, which is at the bottom of your agenda, it is quite short. It's on page 37. And it's been lodged on the basis of complaints having been received. At the time it was lodged, it's clear that it's been done and lodged without any attendance at the premises itself, and it appears there's been no investigation of the complaints, which is of some note when one considers, particularly page 19 of your licensing policy, that you adopt a risk-based analysis to enforcement and control. So if there's been no attendance and no investigation, that might be indicative of the lack of risk perceived by the officers. It's been open since early April, albeit only with the temporary event notices for alcohol, but open the rest of the time as well. The representation was the first we heard of any concerns. No officer has been in touch to discuss the representation, nor the complaints with my clients. The policy, of course, says generally that's good practice. I have emailed the officers. To be fair, they have responded on email. And yesterday, Environmental Health did ring me, not the officer conducting the licensing hearing today. We had a chat. There's an investigation following the complaints. There's been a visit to the premises. There's been, I think, 2 visits to the premises, albeit on the same night, where there were no adverse observations made at all. No doubt a point the officer will expand upon today when addressing you. And that's as far as it's got. So respectfully, I don't see nor accept that there is anything evidence-based that is against the premises produced by officers today. And turning to the evidence, you will see within the representations there's reference to the blender noise that has disturbed residents. And again, I suspect that's presumably from the residents above the premises rather than residents who live miles or hundreds of yards away. And talking about that blender and the noise that is generated by it is, I think, a very important window into, respectfully, the soul of the objections here, because we don't have a blender. The next door delicatessen premises has a blender for smoothies and ice creams. We haven't got one. So the blender criticism and complaint is entirely illegitimate and improperly focused on us. And if we'd been in a dialogue, if we'd had the opportunity to have a meeting, to chat it through, to work it through, that would have been more clearly understood before now. In terms of departure, departure obviously needs to be managed. It's fairly raised by the residents as a point of concern. But essentially what has happened and what will continue to happen, we don't doubt, is that through the course of the evening numbers dwindle and there's no mass exodus of people late at night disturbing residents. We don't accept on the 7th of April that there was a public nuisance or anything of that sort, but it was our opening night. Did people stay a little bit later? Did they leave together? Then probably they did, and that's something that we would want to stay on top of and make sure that we continue to manage through customer interaction with the management, through the CCTV and so forth. But licensing is, as you will, as a committee all know, about balance and reasonableness. It's not about managing away every conceivable risk. If we're not going to grant an application because there is a conceivable risk, then candidly no applications would ever be granted. And on the basis of protecting against every conceivable risk, there would be no licensed premises arguably in the country, and that's clearly not the approach that's adopted. And that approach isn't adopted within your licensing policy. And again, perhaps for the benefit of your legal officer, just a couple of pages to touch on briefly for when the committee later retire. But the business residents and visitors deserving a wide choice of high quality and well managed venues is a clear line set out page 2 and in the introductory pages, and I think on page 5 of the policy, and one that I would invite your attention toward. There's also the corporate plan, which is referenced specifically within the licensing policy on page 7 and 8. And if I may just briefly, I'll just quote you that. Forgive me if I just get it up on my other screen, because it just merits some consideration. I grant you these things don't determine a licensing application, but it is a point of some comment. Forgive me, it talks about an inclusive and safe Vale, environmentally responsible and prosperous Vale, aspirational and culturally vibrant Vale, active and healthy Vale, working with and for communities, supporting learning, employment, sustainable economic growth, supporting people at home and in their community, to respect, enhance and enjoy our environment. And I do say that that does touch on a number of the points that I've made to you this morning. Pre-application consultation is encouraged at page 10 of the policy. Page 14 sets out the sort of conditions that you expect or would hope to see on premises license applications, which I hope you will conclude, many of which are mirrored, if not precisely, in our application. And there's some commentary about external areas on page 17. So you're more than generous with your time. That's probably it from me. Obviously, there may be questions, and if it's appropriate, then perhaps David, John or Anthony may be the better person to answer than me as the solicitor, but hopefully that's a fair introduction to our proposal. We're inviting you to grant it as it's been applied for. We think it's a good application.
Thank you very much, Mr. Phipps. Mr. Evans, have you got any further questions now that you've heard Mr. Phipps's answers to your written submissions?
Yes. Would it be possible to say that at the beginning, I've got no objection in principle to a development on this site, but my concern is that it's a well-run and well-managed development.
Mr. Evans, can I just stop you? You'll have your chance to.
Okay, fine.
To make a representation, but have you got any further questions? Really, it was the thing at the moment.
Mr. Phillips went through. I deliberately, my further representations, I annotated them numerically, and he certainly addressed a number of them. But there are a number of them that basically he didn't address. Am I allowed to raise those?
Yeah, that's quite. Yeah, if they're legitimate questions, now's the time to raise them.
I think the first one is point 3. I don't know what significance is, but the application form was obviously submitted by a consultant whose name was redacted. So I only raised it because the forms, as I go through briefly, do appear to contain a number of contradictions and inconsistencies. And I think from my perspective as a resident, not one living immediately next to the premises, but within reasonable walking distance, I'd like to know what exactly is being applied for, when or if you grant it, what is actually being granted. The first sort of contradiction I set out in point 4. My expertise is not in licensing. I've got expertise in other areas, but certainly not licensing. But my fourth bullet point was the application form states no to live and recorded music. Point 1 in the section on prevention of public nuisance refers to how they will deal with noise from amplified music. I just thought that was a little bit inconsistent.
So would you mind, Mr. Evans, if I just did your points as we go? Otherwise, it'll be a very long question and a very long answer, which probably isn't. So first of all, in terms of the form being completed by a consultant, that's right. It was, and if it's thought that the form has got typos in it, then respectfully, Mr. Evans, I would tell you that it wouldn't be the first form where that's ever happened. And if there's something that you feel is inconsistent, well, no doubt the committee can look at that. But people fill in the forms as best they're able. They're not particularly easy. Not everybody uses solicitors to help fill the forms in. We'll apologise for it, but not so much, I'm afraid, that we say there's anything wrong with the application. The second point is in terms of recorded music, and you'll probably want to hear, I think it's from Mr. Price rather than me on this, but effectively government in 2012 decreed that, first of all, live and recorded music are no longer regulated entertainments at all. So they don't require permission from anybody as long as they stop before 11 p.m. and they're to an audience of no more than 500. So it's perfectly legitimate for a premises to have recorded music. If you think of going into, your local restaurant, there will often be recorded music in the background. That also is not a regulated activity. So background recorded music, nobody needs anybody's permission for that. That's not on the table today, and that's not part of the discussion. The regulated entertainment that you will have perhaps seen on other applications, no part of this application, that's for DJs, for bands and so forth. that either are to a big audience or go beyond 11 o'clock at night. So we do have to control amplified music, even though we're not applying for live or recorded music as a permission.
So, sorry.
Okay, Mr. Evans. Yeah.
Well, I think that's for the committee to consider, really.
No, Mr. Evans. Respectfully, I can see Mr. Romero's on the screen and Mr. Price is on the screen. Don't take it if you don't accept it from me. Please ask them. I'm not. It's not a submission by me. It's the law.
I just find it difficult that if you ask the question again, I've got no expertise in licensing, but if the form asks basically. It has a series of questions, isn't it? Provision of regulated entertainment, and it goes from A to H, and it says no. I accept what you're saying about recorded music. I suppose it's no in the sense that you don't need to apply for it. That's right.
That's right. We're not applying for regulated entertainment, but by not applying for regulated, we can still have background recorded music.
Right. Okay,
perfectly lawfully. We're not doing anything wrong by that.
Yeah, that's fine. But the no against live music means then that you are not applying for live music.
That's right. We're not.
Yeah. Okay, that's fine. Would you like me to?
Yeah, sorry, I cut you off because I thought we'd do it in bits.
No, that's fine.
You ask the next one.
I did say earlier, you're welcome to come back to me as we go along. 6 really, again, is a point of clarification. That there seems to be, again, a slight discrepancy between the descriptions of what you're proposing there. A seated cafe, wine and cocktail bar with accompanying food menu. On the licensable area plan, it's described as a coffee shop, wine and cocktail bar and restaurant, which seems to be a slightly different level of activity, certainly in terms of the food that you're offering, and some of your comments earlier about the vast majority that I think you mentioned that there won't be any vertical drinking, I think was a comment, which I've interpreted is that you won't have people standing around at the bar drinking, people will be seated. A restaurant implies to me that things are a little bit different to a wine and cocktail bar, cafe with accompanying food menu.
Yes, I mean, obviously I can't comment on what's implied by you when you read it. All I can say is the description on the application is the thing that will guide both the legal and the committee. The description on the plan, I don't say is inconsistent. They both say cocktail bar. They both mention wine and cocktail bar. One says restaurant, one says seated cafe. Respectfully, we're dancing on the head of a pin a bit. The committee will make the decision on the licensing activities and the conditions that we've proposed. If you want me to strike through the description on the face of the plan, then of course we will strike through the description on the face of the plan if the committee consider it to be inconsistent, but candidly we don't.
No, fine. And I think I took the opportunity in making these comments to make comments, and I accept it for the committee to consider their relevance or not. The next point is point 9. If you look at the licensably, so the area plan, if you look at the plan actually has 12 seats on the highway, 6 tables and 12 seats. You mentioned, I think in your comments, Mr. Phillips, said there would be 8. So, I mean, that obviously the number of seats is a question ultimately for the Highways Authority, I assume. But again, I think it's useful from the point of clarification that it's 8 rather than 12, or is it 12? I don't know.
No, you're quite right. You're and I'm wrong. It's 12 on the plan, and the plan for the committee's benefit is set out on page 36 of the agenda. When I visited the premises last week, and we took some photos effectively to provide to committee, there were only 4 tables and 8 chairs put out. So I said 8 based on what I witnessed when I attended. But you're quite right to correct me, and I apologise. The application is as per the plan on page 36, and so 12 is the correct number and 6 tables.
Right, fine. The other point with it is the fact that I think you're looking for those tables to be used for drinking up to about 10 o'clock. Have I got that wrong?
Yeah, no, you haven't.
Yeah.
That's spot on.
All I've done is to draw attention to a comment that had been previously I picked up in terms of what shared regulatory services has said in terms of the earlier planning application. And I think the issue is whether it's appropriate for the seating outside to be used to that later period, given its likely impact on amenities, but also its impact on users of the adjoining public highway. Because the difference, as I've pointed out, is that the village, I'm not denying what you said, it's a fair point that the village said the pubs will be open much longer than your client's premises, but they've all got their dedicated, whatever you want, outside spaces away from the public highway. Whereas in this particular case, these tables are on the public highway, and there are issues in terms of, I think, in terms of amenity and public safety, in terms of ordinary users of the highway like myself having to negotiate people drinking outside. That's the point I make there.
Yes, I mean, I hear that point, and the committee that's probably not one for me to answer in the context of a sort of factual point. The committee will come to a conclusion about whether those tables and or any customers that may be outside will undermine public nuisance. Amenity is a planning concern, but public nuisance is the concern. But that's a matter for the committee on conclusion. I can't give you an answer to that if that makes sense, Mr. Evans.
No,
I'm not saying that to be awkward. I'm just treating this as factual answer, or as best I can, factual answers rather than arguments between us, sort of thing.
No, that's fine, Mr. Philip. Thank you. The other point is, it was the other concern I had was this issue for an off license. I think you referred in your earlier comments to that facilitating people to take unfinished bottles of wine home with them, which I would have thought really would, I've done it myself in a pub. Basically, if you haven't finished it, you take it home. But I assumed that really what they were looking at was something more than that. And that was my reading of the application. Again, yes. That's something for the committee to consider. But I do have a genuine concern of basically people buying sort of drinks, and it's not just a bottle of wine, it could be anything, couldn't it? And then leaving the premises on their way home with this bottle with them.
Yes, I mean, I can't really offer you any comment about your anxiety about off sales. It's a lawful activity. There are hundreds of thousands of off licensed premises throughout the country. Appreciate you may have an anxiety about them, but I can't address you on that. I've explained, I hope, fairly to the committee what our proposal is. We're not an off license. We're not a shop. We're not a supermarket. We'd like our customers who finish a bottle of wine, like you yourself have done when you've been to the pub, if you haven't finished the bottle, to be able to take it home without breaking the law. That's it. I should say, I don't think there's anything wrong with an off license, by the way. I'm not here to criticize off licenses. They serve the community perfectly legitimately, and the anxiety about unregulated alcohol, I don't share, but I'm not sure that's particularly relevant to today.
Right. I'll try and go through the others fairly briefly. My point 14 again relates to off-license sales, but I won't dwell on that. I was interested in terms of what you said about the personal license holder. That the is it Mr. Abbott is yes. The designated premises supervisor.
So yes,
and he is a personal license holder, but there will be other people on site who will be personal license holders.
That's right.
Yeah. Okay. Point 16. It's the application form states that an allocated smoking area will be provided. And I just wondered where.
I think it's the tables and chairs outside.
Right. Okay, fine. Well, shared regulatory services are here, so I assume they'll comment on their comments. So that's all I wanted to say in terms of the points I've made. I think the chairman, Councillor Thomas, has said I'll have an opportunity later to raise any other issues?
Yes, I mean, forgive me, it's not for me to, it's for Mr. Price probably to confirm that. Forgive me for jumping in, Mr. Price. Just on the shared regulatory services point, though, Mr. Evans, I don't know that they will be able to comment on that. One can only amplify the representation that you've served, and their representation served is about the receipt of complaints. They don't make any adverse observation about the application, the operating schedule, or the proposal. So that can't be a part of their representation. So it's legitimately a part of yours. So it's probably best you finish that point if there is a point to be made, because there's only 10 lines from regulatory services, and the position of smokers isn't a point in there.
No, accept that. All I was saying was basically the comment I made on Centene was my reading of their comments that have been included in the committee report. So you know, that's my interpretation of their comments.
No, fair enough. I mean,
yeah. So
we disagree on that, but I appreciate that's for later on.
Yeah.
Okay, thank you very much, Mr. Phipps and Mr. Evans. So, Mr. Evans, you will have a chance to address committee formally after shared regulatory services as a responsible authority. So if there aren't any further questions for Mr. Phipps, can I ask Mr. Romero, please, to address the committee on behalf of shared regulatory services?
Yeah, good morning all, and thanks for the time. My colleague is the one that's dealing with all the complaints we've had. We've had about 5 complaints in regards to noise and odour coming from the premises. I was just landed with the application for the premises license, and in discussion with my colleague, we thought it's best that since we've had these complaints that we'd need to put them forward. I know Mr. Phipps has spoken to my colleague yesterday, who advised that she had gone out a couple of times in the last couple of weeks and hadn't witnessed anything adversely with the premises. Also, we've got investigations currently ongoing, especially with the noise, and basically the procedure is the complainant comes to us and then we will send instructions for a noise app to make any recordings. I haven't been able to speak to my colleague to see if any recordings have been made in relation to the noise from the premises, and it might be that the noise we've had specifically to do with the smoothie maker, which you're saying is coming from the premises next door to yours, and mistakenly you're getting blamed for it. You know, that's why we need to go back to the complainant and get further information on that. I think there is a lot of overlap between the planning side, which are not here anyway making any representations, and the noise, especially with the noise. One of the complaints of noise transmission through the building affecting people in the flats above. So I've seen the documents that were sent to me with the sound insulation, and I'm not sure if one of the conditions of the plan was to do a post noise test, but obviously that would require you to get into the complainant's property. Is it the fact that they're not letting you into the property, or is that an issue? If I can ask.
That's right. I mean, look, forgive me, Chair, if you're happy for me just to answer it at this point.
Yes, please do.
Thanks. I mean, I'm bound to make the point, Mr. Romero, this isn't a planning committee hearing.
Yeah, sure. No.
And I, you know, we just do well to remind ourselves that planning haven't made a representation, and there's nobody's raised planning, and it's candidly nothing to do with today. That said, I'm not wanting to obstruct an answer. We believe we've done as much as we possibly can. We've not been offered or able to secure access, and I think that's despite solicitor letters, not from me, but from my client solicitors saying, please, can we have access? To which we've had no reply and we've had no access. So that's why we did the simulated thing. It is fair to flag, though. We've got, Chair, as you'll be familiar with this, we've got a little WhatsApp group going between ourselves on my phone here, just, you know, could you say this or say that, because we're not in the same room, and that's how you tend to manage these things. And I did have a message about 20 minutes, half an hour ago, saying we've just had a response offering us access. So very technically, as of 11 a.m, I think we've been offered access. At 10 a.m, we hadn't. If that makes sense.
No, and
whether that's anything to do with the hearing or not, we'll have to second guess. But
I think it would work from the noise point of view, from our team. Obviously, we've got our procedures where we'd have to go out and witness the noise ourselves. My colleague Sue has been out, like I said before, on 2 occasions and haven't witnessed any adverse activities from the premises. So at the moment, we've got no substantial evidence to say that there is an issue there, but investigations are still ongoing. You know, it's the nature of the beast with environmental health is a slow process to get that information to see if there is an issue or not. When I looked at the schedule for public nuisance, you know, I thought, you know, it's one of the strongest ones I've seen. You know, it's really good. I've seen less conditions and stuff like that on other applications, and when I saw this, I was quite impressed. That's why I was a bit concerned then, that having seen what yourselves had written on the schedule, and then we were receiving these complaints. Was it purely about how the place was being managed? Because it's one thing to write something on paper to look good, and then it's another thing to actually put into practice. But as you mentioned before, Mr. Phipps, we haven't got any substantial evidence to say that there is an issue at the moment, but we are still in the process of investigating these matters. I'm not sure if you want to make any comment or not on that.
Not for me. I think there may be questions, but I, you know, if the responsible authority objecting to the application is saying they haven't got any evidence against the premises and that the operating schedule is one of the strongest that they've seen, I'm not sure there's a lot for me to say, Mr. Romero. I suspect the committee have heard it loud and clear.
Yeah. Thank you, Mr. Romero, for that. Are there any questions for Mr. Romero from anybody?
Sorry.
Mr. Evans? Yeah.
There's been mention of planning, and Mr. Phillips has taken the opportunity to mention planning on a number of occasions. My understanding was you mentioned the planning have not made any representations. I assume they were afforded an opportunity to come. My question though is Mr. Romero, you mentioned yourself about the conditions of planning consent. There were 2 conditions imposed on planning. The second one was that a sound test be carried out within 1 month of first beneficial use, which I presume now you will.
Mr. Chairman, I'm not sure these are questions that this officer can answer. And again, once again, I'm not sure how they are relevant to the application that you're considering.
Plus, well, perhaps if you let me finish, I might be able to he might be able to assess whether the relevance or not.
Okay, carry on quickly then, Mr. Evans. And
all I was saying, presumably you'll be doing that, but the other condition actually stated, which is relevant, I think, to the information that was submitted from Cerrig, was that basically that under the condition of the consent, that there would actually be a soundproofing scheme submitted to the council and actually implemented before first beneficial use of the premises. Mr.
Evans, I think I must have to agree with what Mr. Price said. This isn't relevant to the licensing application. It's a planning matter. The licensing application is stating there's going to be conditions which say that there shouldn't be any noise that causes a nuisance, and that's what we've got to consider, not the mitigating things that are put in place.
I was going to ask a specific question of him, having given the context, but if you're not allowing me, I'll accept that.
Okay, thank you. And are there any further questions for Mr. Romero? No. Well, in that case, then, Mr. Evans, it's your chance to address the committee of anything which you haven't already brought up in your questions.
Given my recent dialogue with Mr. Price, and yourself, I'm very worried that anything I raise would be immediately knocked down on planning grounds. As I said, if the applicant solicitors raised issues on planning grounds, some of what I say is related, but it's related to both areas. So,
if it's related to the licensing and the licensing objectives, by all means raise it. If it's purely a planning issue, then it's not something that we can consider.
So, would it be possible for me to, Mr. Phillips, I think, has raised the submitted information from this company, Carrick?
Well, it depends what you're going to ask or what you're going to say.
Well, if I say it, you can tell me if it's valid or not.
Okay.
Noise is a relevant issue for you?
Yes.
Yeah. Okay. The series of questions I was asking, it refers to the fact that on the 15th of January, the individual who is it M. Annette, visited the premises.
Can you tell us what you're referring to, Mr. Evans?
What I'm referring to is the two-page document from Carrick relating to soundproofing.
Yeah.
And all I was going to ask was, he visited the premises on the 15th of January. Was any relevant council officer, either from planning or shared regulatory services, present?
Again, I can't answer the question. I don't know if anyone can, but it's not really relevant to this, because all that the applicants have to do is to ensure that they don't breach the conditions which they are offering with the license. How they do that is up to them. But Mr. Phipps or the applicants have shared that letter from Carrick showing that they have put things in place. But at the end of the day, it comes down to whether they do actually breach the condition.
Right. So the question I was asking is, they've done this, but no one for the council has vetted what they've done yet.
Can't answer the question because it's a planning matter.
I'm not sure it's a planning matter. It's a question of sound insulation.
Sorry, can I interject?
Yes.
It would be a planning matter because it would have to go through the planning process. So, in order to be accepted as suitable installation, it'd have to be signed off by a planning officer.
On the advice of yourself.
Yeah. So we would say you would need sound insulation, and then it would be the planning officer that would sign it off, not our department.
Okay, look, I think it's better if I'll desist. And thank you for the opportunity of coming along to making some comments, because I feel that some of the issues are inevitably going to go between licensing and planning, and I don't really waste your time anymore.
Okay, thank you very much,
okay.
Mr. Evans. Thank you.
Mr. Evans? Mr. Evans?
Yes, sorry?
Are you saying that you no longer wish to participate in the hearing?
I'm saying that I don't want to delay the hearing any further. And given what's happened to date, yes, I think it'd be easier if I ended my participation. As you know, I don't think these are the best. Why you've chosen to have a virtual hearing for this, I find difficult, and it's been very, very difficult, to be perfectly honest, for me to follow everything. given
Yeah.
my technical incompetence on computers. So
I
I
think-
think
Yeah, I think we all share your concerns on that, Mr.
my-
Evans, but I
my
did
patience is
explain at the
wearing
start.
thin, so I think it'll probably be better for myself and yourselves if I leave the meeting. Okay.
Well, that's entirely up to you, Mr. Evans. But thank you for your time. So then, is there anything that Mr. Romero wishes to say in summing up, or are you happy that you've said everything you wish to say?
I think I'm happy with what I said. You know, I'm not against any premises opening that. We're purely a reactive service and we react to any form of complaints. As I said before, investigations are still ongoing, and it's my colleague that is conducting these investigations and not myself. So if anything does arise from those actions or investigations, then obviously we'll be in touch with the owners of the premises.
Absolutely. Thank you very much. Thank you, Mr. Romero. Mr. Phipps, then it's back to you for your closing statement.
Mr. Chairman, I'm obviously aware that Mr. Evans was given the opportunity to make representations, previously having asked questions of the applicant.
Yeah.
Not entirely sure he did make any representations over and above what he placed in writing, but I'm aware that obviously Mr. Phipps didn't have an opportunity to question Mr. Evans. What I will be doing is asking the committee to obviously attach the appropriate weight to what they heard from Mr. Evans, bearing in mind that Mr. Phipps did not have the opportunity to question him.
Yeah.
Is there anything you'd like to add on that point, Mr. Phipps?
No, I mean, thank you. It's good of you to say that. You're actually stealing a point from my closing remarks. But committee have heard the matter. I've got a couple of observations in closing, but nothing about Mr. Evans.
Okay, thank you, Richard, and thank you, Mr. Phipps. If you'd like now to make your
so yes, and perhaps unusually for me, they will be brief. So. Just in terms of, I know, I see you smiling. You'll be only too aware that I can rattle on a bit. This isn't one of those jobs, sir. So just in terms of planning, I think you've got the point. I think Mr. Price has got the point. But I think it's not just that the planning officers haven't submitted a representation. It's not just that planning is not what we're dealing with today. I think the other point of significance is when you look through the representation, no one's raised planning. And representations and hearings can only develop points that were fairly raised to which the applicant was aware within the context of the original representation. So it's sort of irrelevant on about 3 footings. All of that said, we're not here to cause anybody aggro. We're not here to have a bad relationship with our residents. We're not here to have a bad relationship with our neighbours. Certainly Mr. Evans, who is the one attendee today, if we offline can have a meeting and a dialogue and find a way to make sure that we've got good relations going forward, we're absolutely all for that. And that's an open invitation and no issue with that at all. We don't have your contact details because they are redacted by the authority, but through Yvonne, we can reach out. And if we want to have a discussion, we'd be keen to do that. The second point, and it's fair to make this point, and I make it hopefully straightforwardly to Mr. Romero's face at least, is we were very disappointed with the Environmental Health Office submitting a representation as they did, because the written representation simply says we've had complaints, therefore you should refuse the application. Well, that's how I read it, and that didn't seem to me was a reasonable, fair, proportionate, or frankly appropriate way in which to conduct business, because it seemed to me it was hostile to business. Now, to be fair to Mr. Romero, he's been very generous in his comments today, and it's important that I do say thank you for that, because effectively he said to you today, we don't have any evidence that this is a problem, save that we've had some complaints. We've not done any investigation, save 2 visits, and on both of those visits we didn't see anything to be a problem. And then he even more generously goes on to say, and the operating schedule seems very comprehensive and all-encompassing. And then his final point is, and if they step out of line, well, we will enforce against them. And that's a point that, committee will only be too aware of, whether it's a licensing review, whether it's a noise related enforcement matter or otherwise. So cutting through all of that, there's only one real question here. Is this application, if granted, likely to undermine the licensing objectives? That's the legal test, that's the guidance test, that's your policy test. And if it is, and if the committee conclude on everything that you've heard that it is going to undermine the licensing objectives, you need to refuse the application. And we'll just have to trade as a cafe. But you're an experienced committee. You've read the papers. You've heard from the witnesses. I'm probably obviously inviting you to the clear conclusion that this application, this applicant, this proposed operation, these conditions, effectively endorsed by environmental health, aligned by what we're bound to accept is going to be continued monitoring and supervision by these residents and these officers, allows for the fair conclusion there's no risk to the licensing objectives being undermined here. We're not asking for too much. The hours of application and the lack of any regulated entertainment tell you all that you need to know about whether this is a decent application or not. And I'd invite you to grant it as it's been applied for, with the conditions proposed, with the hours, and on the basis of the plan. The final point to make, important that I make it sort of in the open forum, is we do recognise the work doesn't stop on the grant of the application. The work starts on the grant of an application, and making sure that we're on top of our customers, our operation, and everything that goes with that, so that we're a good neighbour. That's a point that we fully understand and we entirely accept. Thanks very much.
Okay, thank you very much, Mr. Phipps. Are there any questions from the other members of the committee? I don't have any questions myself. I think it's been pretty...
No, I don't have
well
any
covered.
questions, Chair, but what I was going to ask has been answered, so I'm quite happy with, I've heard everything I want to hear.
Thank you, Margaret.
I'm happy,
Jane?
thank you, John.
Okay. Well, thank you very much. Can I thank you all for being present, if that's the correct word, this morning. Thank Mr. Phipps for presenting the application, and thank the applicants for also being present, and thank you to the officers. We will now retire and make a decision, and you will be advised of that decision in due course. Thank you very much.
So may I just ask one question? Just when you say in due course, I appreciate there's a 5-day rule when the written decision will be promulgated by your Democratic Services team.
We will endeavour to get back to you today with
Yeah, I was just going to ask exactly that. Is more and more there's just a phone call or an email that says this is the decision, the reasons to follow, but the decision would be really helpful.
The decision should be with you today. Yes.
Well, that's great. Thank you very much for your time. Thank you all.
Okay, thank you. Thanks.
Thank you.
If I can ask everybody to leave the meeting now, except the members and the legal officer.
Okay, Chair, I'll stop the recording now, and I'll ask the live stream to be stopped. Bear with me a second.